Good morning, good afternoon, and good evening. Welcome to our international webinar. My name is Milton Lucídio Leão Barcellos, and I'm pleased to welcome you all. And I will be with you during the beginning of this morning, afternoon, or evening, depending where you are based right now. This is the second webinar of the total of 3 international webinars based on the present and the future of intellectual property rights, with the qualified view of remarkable academic experts from China, Europe, and North America. On September 25th, we had the pleasure to have the lecture of Professor Dr. Xiang Yu from the Guangzhou University of Science and Technology, HUST, about the challenge of artificial intelligence to patent law and copyright law from the perspective of a well-known Chinese scholar. Professor Yu stressed a really interesting view about 2 different moments to deal with this challenge in the present, with the actual system and actual technology developments, as he called it, weak AI stage, and in the future, with the need of some changes related to inventorship and other considerations about adjustments of our intellectual property system in a strong AI stage. Today, we are really happy to have registrations from different scholars, entrepreneurs, IP practitioners, IP professors, IP students, and researchers from Brazil and many different countries from the America, Europe, and Asia. Up to yesterday, we had more than 450 registrations through the LinkedIn platform, and additional more than 70 registrations through the Eventbrite platform. Thank you all for joining us for this inspiring lecture of Professor Jens. That makes all of us really pleased with the interest about the subject and the recognition of the well-known Professor Dr. Jens Schovsbo as the remarkable lecturer of this webinar, an important and rare opportunity to learn from a remarkable IP scholar from Europe, specifically from the biggest and oldest university in Denmark, founded in 1479, more than 5 centuries ago. About our lecture, Professor Jens Schovsbo is professor in intellectual property rights at the University of Copenhagen, Center for Information and Innovation Law. He got his Danish LLM from the University of Copenhagen in 1991 and earned his PhD in 1996 and his LLD in 2001 from the same university. He has published extensively in Danish, Scandinavian, and international law journals, primarily on intellectual property law, and with a particular interest for the intersection to competition law. He has taught and lectured at a number of foreign universities, including universities in Scandinavia, China, France, and the US. He is the president of the International Association for the Advancement of Teaching and Research in Intellectual Property, ATRIP, and a member of the Scientific Advisory Board for the Max Planck Institute for Innovation and Competition in Munich. Also, he is a member of the Danish Board of Appeal for Trademarks and Patents at the Danish Domain Name and the Danish Domain Name Complaints Board. Today's Professor Jens Schovsbo's subject is based on the European IP policy and the artificial intelligence benefits and challenges. I had the pleasure to see up front the slides of today's lecture, and I can guarantee that we will have a full and enjoyable, remarkable class about artificial intelligence and copyright with some flavors of artificial intelligence and patents and access to data in the European Union context. It is not part of this lecture, but I would like to recommend one really good article of Professor Jens Schovsbo together with Professor Timo Minsing. It's a short article, but really deep, about connections between intellectual property rights, big data, and European competition law in the health and life sciences, published in 2018 and publicly available and part of the ICTSD and SAP publication series. I would also like to say thanks to my colleague, patent engineer Ms. Kelly Janowski, behind the scene, in order to everything works smoothly during this webinar. Before giving the floor to Professor Jens, I have some quick organizational notes. This webinar is being recorded and will be available in a few days in our YouTube channel. The Q&A will be available through the specific chat that you all can see in your screen. Please feel free to address your questions to Professor Jens during the lecture, identifying yourself and addressing the specific question through the Q&A chat. After the Professor Jens' presentation, we will have specific time designated to the Q&A. Professor Jens, I'm really pleased to welcome you, and we are all looking forward to your lecture. The floor is yours.
Well, thank you so much, Milton, for this very kind introduction, and thank you all for joining me. The time is right now high noon in Copenhagen, and it's gray and misty outside, so it's a great pleasure for me to address you on this topic, which I hope will bring a little ray of sun into your days too. It's been a great pleasure to prepare this presentation. Also, it's been a great challenge because the topic is so broad. So in order to make a more focused presentation, I have been forced, so to speak, to make some choices. So I'm going to explain to you in the beginning of my presentation what areas I will be focusing on. And then I hope that in the Q&As we could perhaps broaden the perspectives a bit if you are interested in specific areas. But the first thing, of course, is to define what we are talking about. What is AI? There are a number of different definitions out there, and I have taken great care not to try to spend too much time on defining what I'm exactly thinking about. So in broad terms, AI covers machine learning algorithms that in a way create on the basis of a more or less predefined input. Often AI is described as a spectrum, and I think it's a good way to think about it. It's a spectrum of technologies going for what we normally call weak AI, where AI is simply a tool, and then to the other end of the spectrum to what we call strong AI. At the weak end of the spectrum, AI is simply a tool. An example could be a good old-fashioned screwdriver. Nobody, of course, would think that the screwdriver would attain any rights to whatever uses the screwdriver was put to. At the other end of the spectrum, you have the strong AI, where you have intelligent or creative or generative machines executing and living independent lives, just like the machine Adam in the brilliant book by the author Ian McEwan you can see at the screen in front of you. Right now, the AI systems we have are on this spectrum. They are more, as I will tell you in a minute, to be thought about as tools rather than intelligent, creative machines. So what will I not be talking about? I will not talk about computer authorship. The machines we have today are designed by humans to do specific things. They constitute no source of creativity. So there's really no reason to ponder about whether these machines could be authors in the traditional sense. Also, even if you were to consider them as being authors, copyright law, patent law, indeed law as such, does not recognize non-humans as legal subjects. So I will not focus on the computer authorship issue, but I will point out already at this point that what's interesting about the AI technology in particular in a copyright sense is that the AI technology can give you an illusion of creativity, an illusion of originality. But as I will explain to you, it is just an illusion. As Dan Burke has explained to us, the apparent creativity of the complex systems may be an illusion of a result of an illusion of their opacity. and their apparent autonomy is an illusion of coercive distances. This is an important point to make, and I will get back to that later on. Also, I will not talk about national law, I will focus on EU law, and I will not talk about the neighboring rights, I will focus on copyright proper. So what I will be serving for you is a full dish, a full nice evening out at a restaurant. The main dish is going to be the question how to evaluate the claims for protection under EU copyright law from the would-be human author involved in either preparing or using the machines that create. This is a question I have found in a brilliant article by Jane Ginsberg and Budiato. I have a reference on my last slide. This is what they call the right question to ask, and I agree. So how to evaluate claims for protection. After the main dish, you will have two sides, or rather, after the main dish, the first side is going to be what are the challenges to EU patent law, a brief perspective on EU patent law, and then a brief perspective also about AI inputs. I will be focusing on the main dish very much about what we call the output of AI. So what happens once the algorithm has executed and has generated what it has been designed to do. As a dessert, I will serve to you the good question if there's a need to change EU IPR in order to accommodate artificial intelligence. So let's try to rephrase the question, or to focus rather on the legal issues we have in front of us. AI, as I have been describing to you, is used for many things. You have probably heard about automated journalism. A lot of the articles you read are not written by journalists, but are generated by AI algorithms. AI algorithms can also do fantastic translations of texts from one language to the next. The next Rembrandt is an AI system that has been trained to paint almost like Rembrandt. So what you do is you enter a topic and then it paints almost like Rembrandt. Also, you can find music on the net that's been composed by algorithms. You can find books and trailers, etc., etc. So AI can be used for a host of things. And the important thing to note here is that a lot of AI's output look exactly like what an author does. So an article written by an artificial journalist might look just like an article made by a real journalist, just like a piece of music that has been composed by an algorithm might sound just like a piece of music which has been created by a real living person. But, and this is a central point, the appearance of the end product is not enough to earn it IT protection. So the mere fact that something looks like a protected article, a protected picture, or sounds like a protected piece of music does not make it a protected text or piece of music. What matters to copyright law is the process by which the work was created. And that's the tricky part about assessing originality in AI works. This is what we call the black box problem. Because of the machine deep learning structures of the AI algorithms, the programmers and the users are often not involved in the making of the output. So the journalist, or rather the editor of the journal, would ask the AI algorithm to write an article on Joe Biden's recent challenges in the American election, and the algorithm would do that and make an article. Or you ask the music program to compose a piece of music, and it's going to compose the piece of music. You just type in the instruction, but what happens in the AI would often be beyond the control of the user or the programmer. And this relationship between the human programmers and the users is what makes this a complicated matter. If no causal link exists between the creative efforts of the human programmer or user then there is no copyright protection. To investigate that further, to see what link should there be before or between the creative effort of the human programmer or user, let us focus now on EU EU copyright law. Now, copyright law in the EU states nowadays depends very much on the EU directives in the field of copyright law. But of course, the EU countries have known copyright for a good many years. In fact, copyright was eventually seen for the first time in Europe, in the United Kingdom, and then later on continental Europe. So if you look back on the history of copyright law, I think it's fair to say that copyright law has always been awarded for two basic reasons. The first one is to incentivize the creator. This is in the focus of the copyright tradition. The second reason is in recognition of the authorial efforts of the author. This is the core of the droit d'auteur tradition, the continental European tradition. So most copyright systems would grant protection more or less for these two reasons, to incentivize or to recognize authorial efforts. The important thing to note, of course, is that copyright is granted for a purpose, either to achieve innovation in society or to protect the personal interests of the author. This is also reflected in the basic EU directives. So the Infosoc Directive, which is the most important of the EU copyright directives, for instance, talks about that the copyright should be at a high level of protection because copyrights are crucial to intellectual creations. Also, that copyright is granted to ensure the maintenance and development of creativity in the interests of authors and performers and so on and so forth. And it's also stated in the Infosoc Directive that if authors or performers are to continue their creative and artistic work, they have to receive an appropriate reward for the use of their work. So copyright is granted for a reason. Copyright is granted in order to stimulate creative and artistic developments. The same is the line in the Court of Justice, the reasoning from the Court of Justice, for instance, in the recent decision in the important Pelham case, the court says that copyright should strike a fair balance between the holders of copyright and related rights and the protection of the interests of fundamental rights of users of protected subject matter, as well as of the public interest. Now let's see how these good efforts are translated into the copyright protection regime. So copyright grants exclusivity to works. And the interesting thing is that we have a number of directives in the field of copyright in Europe. You can see the first directive I'm bringing up here is all the way back to 1991. And the first directives we had in the EU were directives aimed at specific types of works. So the Computer Programs Directive, for instance, stated that a computer program shall be protected if it is original in the sense that it is the author's own intellectual creation. The Copyright Terms Directive from 1993 had a similar rule regarding photographs. And the most recent and central directive, the Infosoc Directive, I had already mentioned. It's interesting that it does not contain any specific definition of what is considered by a work, but this directive simply grants authors the exclusive right to authorize or prohibit reproduction of their works. And the Infosoc Directive is a central directive in the case law from the European Court of Justice. Beginning in 2009 in the Infopact decision, which concerned newspaper clippings, the protection of literary work, the court used the Article 2 in the Infosoc Directive I just showed you to say that authors have exclusive rights in their work, And what we mean by a work is the expression of the intellectual creation of the author of the work. Later decisions have expanded on that. We have learned, for instance, that sporting events cannot be regarded as intellectual creations. We have also learned that the functionality or the programming languages of a computer program is not protected either, protected by copyright. In the Piner decision, and very important decision from the Court of Justice from 2013, the court gave us some further notions of how to think about when a work is original. In that decision, which concerned a portrait photograph, the court stated what is the central criteria, that what matters for the photographer's copyright is whether she has made free and creative choices. And the court went on to state that such choices could be made in several ways and at various points in the production of the photograph. So a photographer could make an effort that would give her copyright both in the preparation phase and also in what we could call the execution phase, when the photographer is taking the photograph. Then he could choose, for instance, the framing and the angle of view and so on and so forth. And finally, a creative effort could be made when the photographer selects the snapshot to go on with. Then the photographer could make a personal choice from a variety of techniques, for instance, whether to put the light on this or that side of the person. So in that way, the court is explaining to us that creative choices could be made throughout the whole process of the making of the final product. So what matters is not just the final product, what matters is the process by which that final product has been made. In that decision, the court is also saying that a central aspect is that in order to get copyright in a portrait photograph, the author has stamped the work with his personal touch. So on the basis of these decisions, and you can see there are more decisions, we normally set up what we call the AOIC test for copyright in EU. So according to this test, to be a protected work, the subject matter must be reflecting the personality of its author as an expression of her free and creative choices, and not be determined by technical constraints or by following rules. It must be stamped with the author's personal touch. It must be identifiable with sufficient precision and objectivity. And finally, it must be expressed. Now, before I go into the more detailed discussion about how could these criteria be realized through AI, it's important to note that this is what we in European law call an autonomous concept of EU law. So originality, the concept of originality, should be given an independent and uniform interpretation throughout the European Union. More concretely, it means that national courts may not deviate from these 5 criteria. So national courts should accept all subject matter which satisfy the criteria and should reject subject matter that does not. So national courts may not adopt other criteria, and national legislators may not, in their national copyright acts, have any other criteria than these 5 criteria. So let's turn now to AI and start to apply the AOIC test. Well, the first thing to note is that the AOIC test needs a human to reflect the personality, needs a human to express her free and creative choices, and needs a human to stamp the output with the author's personal touch. In other words, EU law protects people, not machines, as it was phrased by Professor Ricketson in a very fine article from 1992. And it also means that the mere ownership of an AI, the mere ownership of an algorithm, does not give any copyright in the output of that algorithm. It's also clear, and this is clear from the Piner decision I just mentioned with the photographer, that humans may use tools to create. So the photographer can have copyright in the photograph, even though the photographer has used a camera, which is a technical device, as long as the photographer has given the picture a personal touch, either by setting up the situation where the picture is being taken, what we could call the planning phase, in the execution phase, or in the post-production phase. So throughout these phases, humans can have copyright protection, even though the work is created by a tool. The question arises, what happens if the tool takes over completely? In that situation, the AO's IC test points in the direction of no protection. So if the algorithm has taken over completely in the sense that the output does not reflect the personality, neither of the programmer nor of the user, if there's no expression of the human author's free and creative choices in the output, and if the output is not stamped with the author's personal touch, then there is no originality, and then there is no copyright. And the important thing here is also to note that even if the output looks original, it's not enough to earn copyright in this output. So in EU copyright law, non-original works are not protected. Such works fall into the public domain. So what to look for then if we are looking to ascertain whether a certain output is protected by copyright law? We have already learned from the Piner decision that you could put emphasis both on the execution phase and the post-production phase and the planning phase. And this is reflected in the literature. So Verhaar and Gills, for instance, they state that copyright presupposes significant and decisive human intervention, for instance, in selecting the input to feed or train the AI. So if there's significant human intervention in finding out which pictures or which texts should the AI be fed in order to execute, for instance, in selecting the paintings by Rembrandt, which the AI machine can then use to paint like Rembrandt, then that would give copyright protection to the person who had selected that input. Also, selecting the output could give copyright protection. So if there has been a lot of efforts or creative efforts going into making the choices between different selections produced by the AI, then the person who has made those selections would have copyright protection. Finally, drawing up the functional specifications could give you copyright protection in what the functional specifications achieve, but only if the personal touch is carried through from the programmer to the output. Chavez states in a very nice way that there should be causality between the originality effort and the outcome. If there is this causality, a link of causality between the original creative effort of the user or the programmer, and it's reflected in the outcome, then there would be copyright protection. In the same direction, I think Ginsberg and Budiajo are talking about several different kinds of uses of AI technologies. So to sum up, I think AI is most likely going to increase, I think maybe even dramatically, the number of what looks like works. So because of AI algorithms, we're going to have a lot of music, we're going to have a lot of new movie trailers, we are going to have a host of literally texts that's been translated, we're going to have a lot of automated journalism. So the number of what looks like works is going to go up dramatically. I think it's also important to note that if correctly applied, I mean, if the AOIC test is applied in the way it's intended to be applied, then a good deal of these works are going to be filtered out. That means that a lot of the things that are produced by AI are not going to satisfy the test for copyright protection, but are going to fall into the public domain. I will get back to the consequences of that later on, because one could, of course, ask if that is a good idea. Should we try to protect more in order to draw these works into the copyright system, or should we just leave it as it is, or reconsider perhaps how that would affect the overall functioning of the AI technology? I will get back to that later on. Because first, I would like to serve you my first side dish. And the first side dish is on AI and European patent law. And the reason why I made it just a side dish is that I think more or less the same conclusions can be drawn for patent law that I drew for copyright law. So the first thing to note is that it also goes for patent law, that only humans may be inventors. So AIs cannot be named as inventors in patent applications. On the other hand side, there's no doubt that humans may claim inventions made by artificial intelligence, made by algorithms, if only the normal criteria are met. And here we have to remember that there's no requirement in patent law of originality or intellectual effort. It's not enough simply to be able to understand and ascertain the technical implications of certain observations. Then patent protection can be achieved if the normal conditions are met. So the normal conditions in AI are stated in the European Patent Convention, Article 52. And according to that provision, patents can be granted for inventions, any inventions in all fields of technology, provided that they are new, involve an inventive step, and are susceptible of industrial applications. And this means that patents may be applied both regarding the AI technologies themselves and regarding inventions that are made by or facilitated by AI systems. As far as the AI technologies themselves go, these are considered as programs for computers, and under European patent law, programs for computers may be protected unless they are covered by the so-called as such exception in the Patent Convention, Article 52. I don't think there's any need to go into great details about this exception. We can get back to that in the Q&A. So I just make the point that it's a very low threshold. It's easy to satisfy this exception. And as long as there's a technical effect of the invention, it can be patentable. Patents cannot be achieved for mere business models or based only on creative output and so on. But if there is a technical step, then patents may be granted to programs for computers. Furthermore, patents may be granted for AI inventions if they satisfy the inventive step threshold. In Europe, we apply the person skilled in the art test. So the question is whether the person skilled in the art finds that the criteria has been made. That is, there is a certain distance between the new technology and the existing technology. Also, it's a requirement in European patent law that the patent holder, the patent applicant, discloses the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. Now, these criteria apply across the board. And I think that if you apply them to AI technologies, you would find that AI technology may fit within this overall framework. We can use the traditional concepts of European patent law to cope also with AI. However, it's also fair to note that AI technologies may probably challenge some of the ways we are using these traditional concepts. For the inventive step criterion, for instance, it has been suggested that the use of text and data mining technology may lead to an increase in the skilled person's knowledge, which might in effect raise the bar. So if you move from a person skilled in the art threshold to a machine skilled in the art threshold, it might be that it takes more to satisfy the inventive step criterion, and this might then have the effect that the bar is raised, that it's harder to get patent protection. For disclosure, there are issues about the black box problem. I mean, what requirements should you do if it's hard for the inventor herself to understand the technology because of the black box technology? I think, or I understand, that these are real challenges. My point is that the traditional concepts should be able to deal with these challenges. The other side dish turns to the input side of AI technology. So far, when I talked about copyright, I focused on the output. So what is the result of the application of the use of AI? Think of the music or think of the translation. But the other side of the AI technology is that it requires access to data. Access to data both to train. When you have self-learning algorithms, it goes through data again and again and again, and then it learns on the basis of these data. It trains on the basis of these data. But AI also needs input in order to execute its algorithm, for instance, to do the journalistic piece. And data in this concept may include both original works, and if you use original works, you have to respect, of course, the exclusivity which have been granted to the original works. So, for instance, that you may not make copies of original works or part of original works. Also, data, the input may be made out of non-original but protected data. And here it's important to bear in mind that the European system offers a very strong protection to non-original data. We have in Europe since 1996 have had a database directive which protects collections of independent works, data, and so on and so forth. I don't have to go into great details, but just suffice to say that this database protection means that a lot of data which are being collected both by companies and that have data that are being created by companies are protected by the database directive, and therefore cannot be used or can only be used on the condition that the exclusivity rules in the database directive are observed. Also, we have a very recent directive in the EU on trade secrets, and also that directive protects data. So I think it's a really good question, a real question to ask if EU restricts access to input too much. In a nutshell, the EU law offers strong protection for text and data, but almost no specific carve-outs have been made in EU law so far for AI technology. Also in Europe, we have no general fair use exception. We only have a very limited number of exceptions in the Infosoc Directive. We do not have a general limitation for text and data mining. The recent Digital Service Single Market Directive have introduced a very narrow mandatory limitation for text and data mining, but it's only for scientific research questions. So I think for European law, a real issue concerns whether we are protecting input too much for AI technologies to be able to function efficiently. So this brings me to the dessert. It's my starting point that AI does not disrupt the EU IP system. I think that the current concepts we have of originality, invention, inventive step, and disclosure and so on are flexible enough to accommodate this new technology. However, one might still ask two fundamental questions. The first one is EU IPR getting it right regarding AI output? Are we protecting too little or too much? And secondly, is EU getting it right regarding the data input? Are we protecting too much? Looking first at the output side, I think that courts and legislators should be very mindful not to fall in the trap that because something looks like a copyright protected work, it should therefore be protected as such. Also, because someone has invested time, money, or effort in AI technology, it does not automatically lead to protection of the output of those technologies. So when starting to think about whether we should extend copyright protection to all the kinds of creations which are not going to be protected because of the originality criterion, we should try not to focus on appearance of the products. We should instead turn back and ask what are the underlying reasons for copyright protection. So if correctly applied, the AOIC test will filter a good deal of AI-generated works out of copyright. Authorless works will pass to the public domain. Is there a need to change that, you think? Is there a need to expand protection? In order to answer that, as I said, I think you need to look at the fundamental reasons for why we have IPR protection in the first place. And as I said earlier on, copyright is triggered either by a market failure or a personality rights-based need for recognition. There has to be a market failure, or there has to be some other personality rights-based need. And does that apply to AI? Javed has asked, should the law provide additional incentives for machines to execute their code? I think traditional copyright law would say no. Machines would execute their code as long as they have electricity. They do not need exclusive rights. There's no personality to protect. You could ask if companies need incentives to invest in AI technology and if therefore it would be an idea to expand protection. I think these are very complicated. These are questions which is very hard to answer. I think basically the answer should depend on a cost-benefit analysis where you should focus on the overall societal costs and benefits. You should only expand protection if there are societal gains to be made. That is, if you can identify a market failure. If there is a need to focus, if there's a need for companies to have incentives, then you should grant them protection, and if not, you should not. Turning then to the input, should we change the EU laws in that regard? I think there's a good case for looking very closely into that. If we consider AI technology to be a benefit to society, and I think we should, then we have to ask if the systems we have in place, including the IP systems, create unwanted access barriers to unleashing the full benefits of the new technologies. And here I think there's a good reason to ask whether the EU protection of data is too strong. The database directive has been in for revision for ages. Whether the directive is in fact good for anything has always been doubtful, but there is good reason, I think, to focus on that directive and to reassess whether we need this kind of protection in the new age of artificial intelligence. Also, the Trade Secrets Directive has added yet another layer of protection to data, and also that needs to be looked carefully into. So it's going to be difficult, I think, in the future to make sure that we are able to use the AI technologies in a good way. Not so much, I think, because that we don't protect the output of the AI technologies, but simply because the systems we have might create thickets or make it difficult in other ways for AI systems to really harvest the data they need in order to make their specific outputs. Thank you so much.
Thank you, Professor Jens. A pleasure to watch your lecture, and it's really interesting because when you address the way that Professor Burke used the illusion of creativity and illusion of originality, brings some questions related to how to make that different. How can I identify this illusion if I'm facing a real case? And one of the questions is related to that, and I will leave that for the end. But another thing that I would say that from your just perfect lecture, and you did great navigating with both copyright and patent law and also data. And that, as you said, it's really difficult to do that in a short time, and it's a really broad subject to address. Well, one of the things that I would like to do is to do a little connection with the previous lecture of Professor Yu, when he said he splits his lecture in two moments. The moment of the weak AI works, like the present that we can see, even though so it's already really developed, but also with the future and a strong AI work in the future, how we will deal with that in the future. And based on that, it's really interesting, the approach that we are focused on the process, and we are focused on the reasons to exist for the copyright system and the reasons to exist for the patent system, and which goals we want to accomplish with those systems. And you did that just perfectly, and a perfect connection with that. One thing that I would like to ask, and it's a tough question, but I want to raise that if you can answer. It's not easy to answer because it involves like some kind of research about the reason to exist and the goals to accomplish. But what do you think about raising the bar for the inventive step? Is that good or not? Because it seems like if we start to accepting AI technologies and AI inventions and AI technology to evaluate the inventive step as well, is it possible to raise the bar for inventive step? I remember a book wrote by Professor Josh Lerner and Adam Jaffe related to innovation and its discontents and the criticism about the way US system was doing in the past decades and the way started doing, and how that could endangering innovation. So when you raise the bar, or if you get the bar of inventive step down, you have consequences. So I would like to hear about what do you think about those consequences to innovation, if it's good to raise the bar, if it's not good to raise the bar, because if you raise the bar, we will have less inventions, we will have less inventions patentable. If you go down with the bar, we will have more patents, and maybe this is good or not, depending on the goals and the reasons to exist for the patent system. And I think those are my, this is my question, and also, of course, the AOIC test, I think that will somehow answer one of the questions, but maybe you can go deeper on that, because we have 3 different questions, and I will read them here at the chat. Unfortunately, none of them identify themselves. So I will ask if they can identify themselves, but the first question is, in your opinion, who should own the copyright to work that an artificial intelligence produces on its own? I think part of this question is already answered by your lecture, but if you can address this point as well. The other one, Professor James, is if the results of artificial intelligence works only looks like made by humans, how could we identify fraud when someone claims to be the author, but in reality the creation was made by artificial intelligence? Is it possible to identify that this illusion of originality is detectable? And the third question is, can you please explain how exactly can selecting an output invoke copyright? So those are the 3 questions, and the one that I made is just if you can talk a little bit about this inventive step, and please feel free to choose the questions and to combine them.
Okay, thank you so much, Milton. These are excellent questions. The raising the bar question is of course really a complicated one, and I think it's hard to give a cover-all answer to that. But what my response would be when I'm coming to this question from the AI angle is that I think it's important that we don't grant patents to inventions that are made simply because you have a good algorithm. So there might be a situation where there's going to be a race between people with very good algorithms and people not with so good algorithms, but maybe the inventive idea is the same in the 2 situations. So I think the raising the bar is a very good issue to discuss. But if the access to good text and data mining means that you simply have access to more information, you're able in a better way to ascertain all previous patent applications. They might even come better translation mechanisms and so on. So you simply have access to more information. It's going to be easier to see what has already been invented. So if it's easier to see what has already been invented, it's not really raising the bar, it's more bringing the inventive step criterion into its full bloom, so to speak. And if you could make better analysis, you could do correlations between genes and drugs, for instance, because of AI algorithms, and therefore you could do inventions you couldn't do some years ago. Well, you should only protect on the basis of real inventive efforts and real inventive capabilities. So if we could raise, so to speak, the spiral of the level of the technology, then I wouldn't be so scared. The strong AI, how would I protect the strong AI? Meaning the AI that is intelligent in a human sense. I really don't know. I think when it's important not to fall into the trap to see that as the question related to artificial intelligence technology, because the artificial intelligence technology right now is not in the strong AI department. It's a tool that is being used. And as long as we are in this world where AIs are weak, are simply tools, I don't think it's so interesting to think about what could happen in the other scenario. To be smart, to know things about that, I think you should talk to philosophers, or you should read the book I put up by Ian McEwan, which is a wonderful book about a true strong AI intelligence robot. And one of the problems of these robots in Ian McEwan's world is that they turn even smarter than the humans. But that makes them so incredibly depressed because they can see the world created by the humans is such a mess, so they start killing themselves, these machines. And I think if you want to think about strong AI, you should go to literature and to philosophy, and at this point not to law. Well, then the question was, who should own the works that an AI produces on its own? Well, that's in continuation of what I just said. I think that the present system, we don't have any AI that produces anything on their own. We have AIs that are being used by humans. If the AI are so strong, so to speak, that there is absolutely no element of human originality and creativity in the output of the algorithm, then they are not going to be protected and nobody's going to own it. I mean, it's just going to add to the public domain, which is going to be fantastic, because after all, copyright lawyers love the public domain, right? Copyright protection is exactly what distinguishes some types of information from the public domain. So we shouldn't be afraid of the public domain. I really like the question about how to identify the fraud. I think that's a good question. And it raises the broader question, how in the future are we going to be able to identify which works are original and which works are not? And that's going to be really a challenge, because when everything you have out there looks more or less the same, I mean, you cannot really listen to the music and say whether it's a machine that's generated or whether it's a composer. The legal consequences are very dramatically different, because you can freely use the music created by the machine if it's not original, but you cannot, of course, use the music created by the human without clearing the rights. So it's going to be enormously complicated to do this kind of identification, and I'm trying to address that issue when I'm talking about the input problem, right? Because it's going to be really, really hard in the future when we have massive amounts of non-protected, what looks like works. How are we going to deal with those? I think that's going to be complicated. Okay, so how can you have copyright protection based on the selection of the output? I think an example of that could be if you think of an AI, an algorithm that's been designed to take pictures of a city. You have it's just sitting there, and then it's taking a picture whenever it sees something interesting. So it's going to generate an enormous amount of pictures. But then if someone goes through all of these pictures and collects the pictures, find out which pictures would make a nice representation of my feelings of this town, or what could it be, then selecting the number of huge, selecting from the huge amount of pictures made by the AI would certainly grant you copyright protection in the exhibition you would make on the basis of that.
Perfect, but in that case, I would have copyright protection for the selection, not for the picture itself, right?
Yeah.
Perfect. Thank you very much, Professor Jens. And I saw some other points, but all related to if they have the possibility to have your contact information, and we just send the email that is publicly available to talk with you. And that's it. About the questions that we had for this webinar, I think we have no other one. Yes. I cannot see no other questions. Well, I just have to thank you a lot, Professor Jens, and I could say that the approach that you did in your lecture is really interesting, in the point that I think the biggest question is, we are facing a different way of looking IP rights when we talk about IP generated by a machine, by an artificial intelligence. And I think the questions that you made are the most important ones. the question that should we treat equally as we were treating, it seems like we should not. So probably in the future, we will need to have some kind of other regulation inside or outside the intellectual property rights. But for sure, in my point of view, I think we're gonna have to study more to understand and study more to have solutions for this completely different way of kind of creation. Kind of, because when we talk about creation, probably we are talking about human creation, not machine creation. So it's really interesting, and I think we have a lot of questions, but are really good answers as well. And thank you very much for including the quotes for Professor Burke, Professor Greensburg, Professor Gervais, that are also members of the ATRIP, that Professor James is now the president. So thank you very much for your lecture, and as we told before, the lecture of Professor James will be available in the YouTube. And I don't know if you want to have your final remarks, Professor James, before we end this webinar.
Just let me thank you once more, Milton, for inviting me. I normally meet you once a year at the ATRIP conferences in the physical world, and we haven't done that this year. So it's good to see you here, and thank you for putting together this wonderful seminar series. And thanks to the audience and for the questions. Feel free to contact me. I put my contact information on my very last slide, but I think I forgot to show it. so feel free to contact me if you have any questions. Thank you so much.
Okay. Thank you very much, Professor James. Thank you to the audience and its important questions addressed during this webinar. I'm positive sure that Professor James' lecture was as instructive and enlightening, I would stress that, and enlightening to you all as it was for me. I hope to see you all in the final lecture of this webinar that will be in November 27th. We didn't start to send the announce yet, because we are defining with Professor Burke, Dan Burke, about the title, and I think Professor Burke is also struggling with the wide subject of proposed in this series of webinars connecting Asia, Europe, and US. But as soon as we have it, we will release. And I wish to you all a wonderful weekend, and I hope that you enjoy your weekend. Professor James is getting closer to the weekend than we are, since here in Brazil we are just in the beginning of the Friday. And I wish to you all a really enjoyable weekend, and please take a look on the enlightening lecture of Professor James, and think about the questions, because I think we need a lot of work to do in the future to regulate this kind of creations related to artificial intelligence. Thank you again, Professor James, for your kindness, for accepting this invitation, and thank you, Kelly, for behind the scenes being so perfect as always. Thank you all, and see you in November 27th. Bye-bye.